Hello and welcome to my webinar on licensing your intellectual property. I'm going to share my screen and just jump right in. Okay, so this is the Serenity series, Legal Learning for Intelligent Entrepreneurs. And today we're talking about how to expand your reach through licensing your IP. First, a little bit about me. Just make sure I'm recording here. Yep, awesome. Okay, so my name is Michelle Whitehead. I am a homeschooling mum, a lawyer and mediator by profession, and also an entrepreneur, running my own online law firm from the comfort and security of my own home, just like many of you will be running your businesses. And I've got a lot to cover today, so I'm going to just race through it all. To begin with, we're going to look at what can be licensed, what intellectual property is capable of being licensed. So intellectual property is the creations of your brain, your creative output. And it can be embodied in your copyright, which is all of the images that you create, the content that you write, and the videos that you record, everything where your ideas are made concrete in some way. Although it's a little bit more complicated than that, but at its basis, that is what copyright applies to. It doesn't apply to ideas. Those come under trade secrets, which we'll cover in a minute. So copyright is all of the material in which your ideas and your methodologies and your modalities are embodied, made real, brought out into the world. It's all of your creative output. Trademarks are the hooks on which your business reputation hangs. That is your business name, your logo, your branding, your catchphrases and hashtags, the way that people recognize you, the way that a consumer in the marketplace knows immediately that's who I'm going to work with. And you know, they see a post scrolling past the screen, they see it, they know it's you because they recognize your trademarks. Trademarks can be both registered, which is where you've gone through the process of recording them with the intellectual property body in the country where you live, or they can be unregistered, which is where you've built up a history of use through using them to sell your goods and services over time. And so people recognize them. That ability to be recognized in that's embodied in that name or that image, that logo, is something that you can protect as an unregistered trademark. And then we come to trade secrets. So as I said before, copyright doesn't protect ideas. It doesn't protect processes. It doesn't protect concepts. And these aren't trademarks either. What they are is your trade secrets. And trade secrets are only protected so long as they remain secret. So the secret sauce that makes your business so spectacular, the things that you teach people within your courses, and hopefully you'll have a course agreement that keeps it secret by protecting what they can then do with it and what they can share of that material. Those are your trade secrets, and they are an important part of your intellectual property when it comes to licensing. So what are the advantages of licensing? Why would you want to consider it? The advantages of licensing are, firstly, that it expands your reach without expanding your workload. It helps you retain quality control so that you can protect your reputation and creative vision while still allowing your work to be out there, reaching a wider audience. And it helps you keep a consistent brand identity and presence in the marketplace while growing beyond the capacity of what you can handle on your own. So what are some examples of licensing arrangements? Because I know it can be difficult when I'm talking in the abstract about licensing to actually imagine how it works in practice. So some of the licensing agreements I've been asked to write recently are things like course facilitators. So someone has built up an amazing course. They've had graduates go through, they've gone to the highest level that they can go with that course. And then they start saying, I love this work. I want to be able to teach it to my clients. That, but of course, you don't want them to go out and just hand them your course and let them to go out and start setting up your course. And you don't want to take them on as employees, because that's a lot more administrative burden. You want to be able to give them that permission to go out and teach your material to a wider audience, but under a license, so that you're protecting what's important to you, and as I said, maintaining that brand reputation and that quality. Another place where licensing comes into existence is when you have certified practitioners. So for example, rather than allowing someone to go out and teach your material, you're giving them an accreditation to go out and practice that material. So they have the ability to, for example, display your trademark, your business name, your logo, your brand on their websites and advertise themselves as a certified practitioner of your method. You know, and there's that, you know, they can't go and facilitate courses in it, but they can use it in their own clients, and they get to advertise their association with you and the fact that they have trained through you, and so you license them to use your intellectual property for that purpose. Another type of licensing agreement is end user agreements. These can be for software, but they can also be for products and, you know, courses and modalities and things like that. And then the final one that we know probably most commonly when we think of traditional licensing agreements is things like merchandising. So just jump back to end user agreements. That can also be for things like if you create music that can be used for meditations, if you create something that someone else wants to have the right to use in their business. It can also be for people like graphic designers who are creating logos and images, and the agreement that they have with their clients that says, you know, I retain the copyright, but you can use it for these purposes. That can also be a kind of end user agreement. And then, as I said, there's the merchandising, which is things like, you know, imagine the Disney t-shirts and the things like that. It's where you have a really strong brand and you license someone to take that brand out and use it in a novel way. So apply it to products that they're creating. So for example, in the context of the people I work with and my clients, it could be something like you have a new healing modality that you have invested a lot of time and effort in building up. You've made it very popular. It's a very strong brand. And someone says, hey, I could create a range of, you know, products that support people who are using your modality. So, you know, immediately look at the thing on my desk, which is the self-love tincture from Naughty Naturopath Mum. But for example, if she, having built her brand, didn't want to actually create the droplets and things, then it could be licensed. And in this case, it actually is. So I know it's by Alicia Lynch, who is the Naughty Naturopath Mum, but you know, you could license someone else to create those products, that merchandise, which would complement and extend the benefits offered by your brand. So what is a license? And where you can tell we've moved back into the serious stuff here, because all of the slides from now on are pretty much going to be like this, lots of text. So I'm going to try and not make it overwhelming. If you have any questions, please feel free to put it in the chat box or afterwards to email me at michelle@michellewhitehead.com.au. Let me know, or leave your comments on the YouTube video if you're watching the recording, and I'll be happy to try and answer your questions for you. So a license is a contract that authorizes someone else to commercialize your intellectual property. And as we've seen, there's a number of different types of intellectual property that can be involved. And even in that, we didn't go into the other types of intellectual property, which include patents and designs, and there's even more. But trademarks, copyright, and trade secrets are going to be the most common for the people who I generally work with. The thing to remember about licenses is that it's not a license to print money. It's more of a golden goose, goose that lays the golden eggs. It's creating a collaborative, long-term relationship that requires mutual trust and commitment. So it's something that you have to nurture and be really prepared to commit that time to. Now, when you license someone to use your intellectual property, you are keeping control over how that property is used, who it's used by, and what it's used for. And there are some restrictions and things. We're going to go through a lot of detail about what goes into that licensing contract. But at its very basic, that's what you're doing. You are giving permission to specific people to use particular specific parts of your intellectual property in a particular way and for a particular purpose. And the biggest thing to think about when you're setting up your license or beginning to plan what your licensing might look like is that to keep that fine line between a license and a franchise in mind, because a franchise has massive regulatory hurdles and acres of paperwork. You have to give your licensee, your franchisees, access to your business finances. You have to give them massive cooling off periods. There's a whole lot of regulation involved in it. And just the fact that you're calling your license a license doesn't stop it from being a franchise. So the regulatory bodies look at the actual characteristics of the relationship to determine whether it's a license or a franchise. They don't just base it on what you've called it. So it's really important to understand those differences and to walk that fine line. The most important aspects to remember are that licensees have independence where franchisees don't. So licensees are offering your IP as an income stream that complements their own business, and they retain full control over how that business operates. So they get to set how much they sell the product, sell their stuff for. They get to control, who they employ and what they wear and all of the other stuff. And how they promote it. So there's no mandatory system of marketing. There's nothing that you can enforce that they do, although you can put some restrictions and you can provide guidelines, which kind of hopefully avoids that crossover. So it's going to be done carefully and be really clear about the fact that they're just guidelines rather than requirements. So think of McDonald's or Starbucks or one of those big franchises or Gloria Jeans, and no matter where you walk into one in the world, they're all the same because they have those restrictions around marketing, around uniforms, around appearance, around approach. Whereas with licensees, it's quite different. It's more an incorporation of your intellectual property into their business in a mutually beneficial way. So licenses can be exclusive or non-exclusive, and we're going to start by looking at exclusive licenses. Exclusive licenses are the right to commercialize IP to the exclusion of everyone else, and that can include you, unless you make it really clear that you still have the right to use your own IP. If you're granting an exclusive license, then you could actually be shutting yourself out. And this is often useful if you've created something on the side and you just want to let someone else go and run with it, but you don't want to have the hassle of doing it all yourself. You don't want that hands-on involvement. You're still focused on your main business, But at the same time, you don't want to just assign or transfer it, give it away, or sell it and lose it entirely. You want to keep it. You may want to come back to it at a later date. You may have other reasons for wanting to hang on to it and continue to benefit from it. But in the meantime, you're going to give it to someone else so that they can grow it in whatever way the contract allows them to. Exclusive licenses often involve a very significant investment. So they tend to be expensive because the rights that you're handing over are so broad. You can still limit them by territory or time. So you can give someone an exclusive license to commercialize your intellectual property in Australia, for example, and you can give another exclusive license to someone to have one of the states of America. You can have different licensees with exclusive rights over each state, for example. And you can limit it by time. So you can have an exclusive license that lasts for maybe 5 years or 3 years, or it needs to be long enough to allow them to make good use of that license. But there's a time limit to it. So at the end of that time limit, the rights revert to you. And it can also be conditional. So you can write into the contract that you're allowed to continue using it as well. So it's exclusive against everyone but you. And as I said, it has the advantage of minimal involvement. You can just hand it over. To some extent, you still have to retain your quality control if you want to maintain your ownership of trademarks, for example. And you want to make sure that they're doing the right thing with it so that you can terminate it if necessary, and we'll talk about that later. And as I said, it's that difference from actually transferring or assigning trade, which is selling your intellectual property. So it becomes theirs. They take over full ownership instead of having a right to use it. The more common one that I see in my business is non-exclusive licenses. And a non-exclusive license gives someone the right to use the intellectual property along with all the other license holders that you grant. Non-exclusive licenses have the potential for unlimited expansion. So they can actively grow your business's reach because you can have as many licensees as you have people who want to be licensees. Although you might want to cap that to be fair to the people who've been granted the license, so you don't have that exhaustion of the marketplace. Non-exclusive licenses have the advantage that they're often a lower investment for the licensee, so people are more willing to take them up. And you can set them up to be either collaborative or competitive. So, for example, a collaborative non-exclusive license is where you have a community of licensees and you all help each other in your marketing and your branding and discussing how your business is going, and you're all working together for the improvement of the brand or the product that you're selling together. And then there's the competitive license, in which case you sort of let your licensees free and they're basically competing against each other for clients. And every license, tends to be a bit competitive, but the more effort you put into maintaining and building that collaborative culture around your license, the more you get that sort of relationship happening. And a collaborative relationship is always going to have less conflict involved than a competitive one, and so it's often easier for you to manage. With a non-exclusive license, you have more responsibility for enforcement of the intellectual property. So, for example, if you're giving someone an exclusive license, it's reasonable for them to take over any issues that crop up with the intellectual property becomes their responsibility. Whereas if it's a non-exclusive enforcement, kind of the buck stops with you in terms of protecting the brand and ensuring the due diligence and the vigilance that's necessary to make sure it's only being used in accordance with your license. So when is the right time to go into licensing? And this is the how long is a piece of string question. Generally, I see people thinking about licenses when they have a solid, well-known brand with a proven track record for sales. So they have that attractive, strong business that other people want to be a part of and to make a part of their own. It's usually good to have a pool of interested people ready to go who are familiar with your work and want to integrate it with their own work. And that's talking about the course type. You know, if you're thinking about merchandise licensing, then that could be something different. You might only have one person who has a fantastic idea for a product that complements what you're doing. And so it's more of a collaboration or a license that, you know, you only need one person then. But if you're thinking about that kind of practitioner license or that group facilitator, course facilitator license, then having that pool of people who've already graduated through, who know what your values and vision for your business are and who you trust to support and promote those values and vision is really important. And it's also important that you're not at that startup stage. Like, you don't want to leap into licensing if you don't have the systems and resources and processes in place to manage your own business and your own workflow. Then you're going to find trying to manage licensees is absolutely overwhelming. So really make sure you have all of your foundations in place and you're really comfortable with the stability of your business before you start extending it to other people. Quality control is one of the most important issues in licensing agreements, particularly if you're licensing your trademarks, and absolutely essential if they are registered trademarks, because under the trademark law, if you don't institute and enforce quality control, that means you risk not only damage to your business reputation if they're using your trademark in a way that you don't appreciate, but you also risk losing your right to own it, because the court cases are very clear that in order for you to continue ownership of a registered trademark, you must be able to prove that you, as the owner of the trademark, have actual active control over it. And so that doesn't count with just sort of signing a license with someone and then letting them go out and use your business name and your logo wherever they want to. You've got to show that you are actively involved in knowing what they do with it and confirming, you know, that you can stop them doing something that you don't like and that you're giving them permission on an ongoing basis for what they're doing and the use they're making of your work. However, this needs to be, the fine balance is here. They also need to maintain their independence, or you risk being characterized as a franchise. So it's a really fine balance. And so you need to put thought into how you're going to do that monitoring, whether you're going to do audits of their social media presence, how you're going to prove that you're maintaining that actual active control at the same time as you prove that you're allowing them their independence. Next, we're going to look at confidentiality. So this is particularly important for your trade secrets. Trade secrets are only intellectual property while they remain secret. Once they're in the public domain, they become ideas and concepts that anyone has the right to use. So the way you protect trade secrets, while copyright is protected by legislation, trademark is protected by legislation, trade secrets are only protected by contracts. So you have to have restrictions in your contracts around what information can be shared, how it can be shared, who it can be shared with. And this often requires an additional contract protection above and beyond your license. So for example, particularly if there are situations where the people you have licensed to use your trade secrets are going to be imparting those trade secrets or disclosing them or discussing them with other people who aren't in that contract with you, then you want to have them also signing non-disclosure agreements or contracts. So one of the easiest ways to do this if you're a course facilitator is to create a course agreement between that facilitator and their students, which your contract with them, the licensing agreement, requires them to use. So for example, you might have them need to provide you with class lists or copies of the signed agreements so that you know that everybody that they're teaching the material, your trade secrets to, is also going to protect that information and needs to keep it secret and keep it confidential, not disclose it outside the bounds of what's allowed. And they can be really difficult when it comes to enforcing those, because in that case, it would be something that you and the facilitator, the licensed facilitator, would need to enforce together against a student who had breached that workshop agreement or that course agreement. But so confidentiality is something you need to take really seriously and have good discussions with your licensees so that they really understand their obligations in that regard. One of the most important things to do before you even think about starting up a license is to get really clear on your own intention. And think about why you're releasing this material and creating the license in the first place. And there can be numerous reasons why you might want to. One is obviously going to be profit. You know, increasing your income streams and expanding your brand awareness. So reaching into marketplaces where you wouldn't be able to go on your own. So that might be into other niches, other modalities. It might be into global territories, internationally. It may be just beyond your local. If you're a hands-on practitioner and you're licensing other practitioners, you might be expanding into other locations, other physical locations. To taking that message and those methods into new markets has an advantage for you, expanding the reach and really getting your message out there. And it can also be a way to reward your faithful followers. So the ones who've been with you from the very start, who have really supported you, you might want to be able to reward them by giving them that independence and proving your trust in them by allowing them to take it further and make it their own, put their own spin on the work that you've been working together at for so long. There are ownership issues with licensing. One of the things to think about is the advantages and disadvantages of holding companies. So you really need to get clear on who owns the intellectual property. And a lot of financial advisors and accountants that I've spoken to and had advice relayed to me from my clients is that, particularly if you're a sole trader or you're a company, there are advantages in having an independent entity, such as another company, that's set up specifically for the purposes of owning that IP. Because that means the people who are actually engaging with the using the IP out in the marketplace and are exposed to that risk, there's kind of a firewall between them and the people who own the IP. So even if you get exposed to litigation or things go dramatically wrong for you and your licensees, the IP assets remain held in place. One of the disadvantages is that this does increase the costs, because you've then got the administration costs of an extra entity. And it also, you need a licensing agreement between you as the trading party and the company that's holding the IP. So once again, there's that thing how the owner of the IP has to be able to control how it's used. So if a holding company that you've set up owns the IP, they have to actually license you to use it so that you can license other people to use it. So that, you need to have a license that allows you to grant sub-licenses and things. Another ownership issue is whether you actually pursue trademark registration before you begin licensing. A registered trademark has a lot more value and provides a lot more certainty for your licensees, because you are guaranteed that exclusive ownership in the country where it's registered. Once again, that increases your costs though. So it's an investment in the value that you're going to be providing to your licensees. Even if you don't engage in registering a trademark, you must, at the very least, do your due diligence, because there would be nothing more dangerous than setting up a license, taking money off people, licensing them to use your brand name when that brand name is actually owned or registered to someone else as a trademark, or has a prior history of use, someone else has the right to it as an unregistered trademark. So you absolutely must do your due diligence. Make sure that your intellectual property that you're licensing is yours to deal with. Another knotty problem when it comes to ownership and intellectual property licensing is who owns the improvements created by your licensees. So for example, if your licensees take your marvelous material and run with it and create something brand new and spectacular in their own right, but that has your IP at its base and foundation and couldn't exist without your IP, what rights do they own and what rights do you own, and how do you make that fair? It's a really knotty problem that can only be considered in the context of specific circumstances. But it is something that it's very important that you turn your mind to. And then there's the question of who owns the goodwill. So goodwill is the belief that your clients have in your reputation. It's what keeps them coming back to you rather than going to someone else. And if you're externalizing that into your brand and you're allowing other people to go out and use that brand, is the goodwill accumulating to the licensee who's providing the service, or to the brand, the type of the service that it belongs, that they're coming to? Like, are they coming to you for, XYZ service, or are they coming to the facilitator because she is who she is? It's another tangled, knotty question that it's really important to think about. And in many cases, it will depend on the nature of the service or the nature of the product, and the nature of the brand, and the size of the brand, and the relationship you want to have with your facilitators, and so on. And it becomes important when the relationship ends, because when the relationship ends, in many traditional barbed wire type license agreements, you're basically saying, once the relationship is over, all the goodwill stays with the company that, or the entity or the person, the business that owns the IP, and you've got nothing despite the years of promotion and publicity that you've put in as a licensee. So, you may want to write something in there that allows them to be compensated to some extent for the goodwill. And whether you put a fixed price on that, or whether it is conditional on various benchmarks, or whether you take that traditional approach and just say that, the goodwill stays with the brand, is something to definitely consider. So what are the prerequisites? The prerequisites are who you want to work with. It's the thought you've put into determining how you choose your licensees. What are the conditions for eligibility? And these can be particular characteristics such as ethics, their business experience, their compatibility with your values and vision. But those characteristics are a bit airy-fairy, a bit. How are you going to determine them? You need to have really set procedures. So whether you have an interview with your licensees with a set of questions that you ask them, and then you go based on, you bring in intuition and gut feeling based on that, whether you have a set of tick the boxes requirements. You need to make sure that they are an aligned person who has the integrity that you require, so that you can trust them with what is, in effect, your business baby. And then there's going to be the external requirements, things like their qualifications, their certifications, what insurance they have to have, whether they need working with children checks, whether they need police checks, whether they need all those kind of external accreditations that prove them, that qualify them for doing the work involved. There's going to be levels of training that they need to have had. Perhaps with you, maybe you require that they have gone through certain levels of the courses that you offer to be eligible before they can offer those courses themselves. You know, they might need to have done a course at a particular level 3 times before they can offer to teach that level, all those sorts of things. And there could be that, that ability to level up and to take their license to new levels. You might require them to do ongoing professional development with you or with someone else in order to keep their skills up to date. And the important thing to think of before you approach your very first licensee is how comfortable you are with saying no. Because if you're not comfortable with saying no to someone, you might want to set up that your licenses are available by invitation only. You know, you might want to have it by written application where they have to address a set of criteria that you can then vet and make it really obvious that not everyone who applies gets accepted. Rather than throwing it open and letting everyone sign up for sales calls when you're going to have real trouble saying, actually, I don't think you're a good fit to be one of my licensees, go away, and then dealing with their disappointment and their upset around being rejected. It's an important consideration. Next, we're going to look at the nitty-gritty details. So in every licensing agreement, you need to have these things covered off. You need to have the term, which is how long the license lasts for, and any conditions for renewal, whether it can be renewed, whether it's a one-off, whether they have to do further training to qualify for a renewal of the license, whether they have to have met certain benchmarks, you know, have sold a certain number of products or run a number of classes in a time frame in order to be able to renew it, so on. You need to set their territory if that's important, or to make it that it is non-exclusive and there is no territory. And if it is a set territory, you need to cover off any ability to expand, you know, whether they have the ability to apply to extend into new territories or to move territories. You have to be really careful about price fixing, but at the same time, you may want to be setting a recommended retail price. You've got to be very, very careful there that you're not trespassing on the consumer law provisions around cartel conduct and limiting competition in the marketplace. So while you can't say how much they're allowed to charge for particular courses, you can recommend a retail price that they can then go above or below. There may be authorized training materials involved, particularly if they're doing courses. And, you know, you have to set out the procedures for how they access that training material, where they buy it from, all of that sort of stuff, who's responsible for postage, all of the nitty-gritty details, really, that think about the whole process, how it's going to work from step to step, everything that's involved. You need to think about administration and record keeping, both for you and for them, what records they need to keep, and when and if they have to show those records to you, what administrative requirements are on them, and also your administration of your licensees. How are you going to do it? What systems have you got in place? You need to make sure that the contract puts an obligation on them to understand and comply with any local laws in their territory, so that you know, they don't go breaching local laws, getting in trouble and causing, bringing your brand into disrepute or causing problems for you because their failure to comply with the laws of wherever they are. And you need to set your jurisdiction so that no matter what kind of problem evolves with your licensees, it's going to be dealt with according to the laws of your land, particularly if they're internationally, but even if they're interstate. You need to make sure that you are all you're all agreed to be compliant with a particular set of laws in respect of dispute resolution and any contractual disputes. Okay, we're running out of time and I've got heaps left to cover, so we may actually run over, but that's okay, I'm sure. License fees and royalties are the next thing to consider. So, and you might notice, sometimes I've used S and sometimes I've used C when I'm spelling license. It's one of those crossovers between English and American spelling. And while I try to be really really, really aware. At times it gets the better of me and I just run out of time to be that pedantic about which I'm using. So if you have noticed any inconsistencies, I'm sorry, please forgive me. I love you, thank you. We'll get there anyway. So there are two main types of payments involved with a licensing agreement. The first is license fees, and these are usually a one-off upfront payment that's made in consideration for the grant, being granted the license. They can also be charged, your license fee can also be charged on renewal. So in order to renew, before you can renew your license, you have to pay a further license fee. And in order to ensure that your licensees are getting sufficient value, other than just this sheer grant of the license, which can be valuable in its own right, you can also tie that license fee into some further training or value or supervision that you provide to the licensees in order to help them justify the payment of that license fee. And then there are royalties. Royalties are an ongoing payment. They may be a monthly fee. They may be tied to, there may be a fixed amount, or it may be conditional on certain circumstances or factors. For example, it might be tied to their profit or the number of courses they deliver or the number of students they have in those courses or the number of items sold or some other benchmark. So really putting that thought into how the payment system is going to work in terms of those two things, the license fee and the royalties. Another thing that's very important to include in your licensing agreement is information about the restrictions that are involved. So these are some common restrictions. There are more that can be included. One of the most common restrictions that I see in contracts that I draft for my clients is that a license needs to be personal and non-transferable. This allows you to control who your licensees are. If a license is transferable, that means that they can then sell that license on to someone else, whereas you want to be able to vet the people who are your licensees. And this can change with the value of the license. For example, if it's an extremely expensive license and someone has an issue where they can't continue to operate that license, it may well be worth them being able to sell it on to someone else with you having the right to veto who it is sold to. So you have a right that, they have to get your approval of the incoming licensee, but they can still sell the value that they have in that license to someone else. So particularly with exclusive licenses, you may want to make them transferable. But for non-exclusive licenses, then you absolutely want to make them personal to the licensee and non-transferable. You also want to restrict their ability to grant sub-licenses in most cases. So for example, if you have facilitators who are delivering your course, and the agreement with their students is that their students can go and use that material in their own lives and in their own practice, but they can't go on and teach it to anybody else. So there's that restriction on that grant of a sub-license. Alternatively, if you're setting up a like a global distributor type of license where you've got someone in another country who's going to be you in another country, you might want to give them the right to grant sub-licenses of a particular type to people in that country to then expand the reach again. So it becomes like that web of growing connections. Another restriction that's very common is that the IP, the intellectual property, is only to be used within the context of the licensed activities. So this stops people going off and using it for anything that they want to. They can only use it within the confines of the license. You might want to have non-competition clauses. So for example, to prevent your licensees from registering a deceptively similar trademark, a business name, a logo, that could be confusing, that could cause people to think they were associated with you after they had finished, or to build concurrent brands that, you know, that is confusing for people. You might also want to have a non-competition in the sense that it stops them from offering a similar service for a particular period of time after the license ends. Those are really complicated and have to be very carefully drafted, but that kind of non-compete clause is often another common one, because you don't want someone cancelling your license and then going out and offering something similar based on ideas, although you would have that confidentiality around your trade secrets, which could continue past the end of the license, which would hopefully stop them from actually relaunching under a confusingly similar brand to teach the same materials. And another restriction that's very important is to tie them off so that they're not acting as your agent, so that they can't bind you into contracts or make agreements on your behalf. Liability and indemnity is a really big part of licensing. And at this stage, I just want to raise issues for you to think about, because again, it's very contextual, it's very circumstantial. There are a lot of factors involved that are specific to particular situations. So I can only be very generic and get you to think about the types of problems that could occur. So the first one is the responsibility to the end user for the quality of the service or product. So that's the students or the people who buy the product. Who is their contract with? Is it with you or is it with the licensee? And who is responsible for that delivery of services? Normally it would be the licensee who bears that responsibility. Then there's who is responsible to the licensees if there's an issue with the intellectual property. And I mean, if it is an exclusive license, then you might be sheeting that responsibility home to the licensee. Whereas if it's a non-exclusive license, you might be retaining that responsibility. It would also depend on whether the issue with the intellectual property ownership arose beforehand, so that you've actually licensed property that you don't have the rights you claimed to have. That can be a massive issue for licensing, and why your due diligence is so important. Or whether, you know, who's responsible for that ongoing vigilance and due diligence over time to make sure that the IP is not being used by anyone who doesn't have that right to it. You would normally have in your license agreement a requirement that the licensees advise you of any problems that come to their attention as soon as possible. And you would also have a division of responsibility for enforcement and any defensive litigation. So who has that responsibility for paying legal costs? Are they shared? How are they shared? In what circumstances are they shared? All of those sorts of things. Another important thing to think about is cancellation. So what happens if your licensee's circumstances change and they want out? They no longer want to be a license holder. It's best to think from the start to admit that this is likely to happen and to provide a clear procedure for relinquishing the license so that they're not tied into a situation that is no longer tenable for them, unless that is something that is really important to you and is clearly explained, that there is no way out for them, that they are stuck and they are making a commitment for a specific period of time. But just to think about the practicalities of how that will work, particularly if it's a non-transferable license. You know, if they're required to pay royalties, you need to fit in some flexibility and discretion if you're going to make it that there are no cancellations. You should also think about notification periods to ensure that if you, for example, to ensure you're not left high and dry, particularly if they have exclusive ownership of a territory, you will want to be able to arrange someone to take over that territory rather than suddenly abandoning sales in that area altogether. And a consideration of the consequences. So what does it mean for them to no longer be able to use your intellectual property? How is that going to change their business? What things do they need to change? They'll probably need to revise their website, their marketing copy. There will be a lot of consequences, and the consequences for you as well, which again are going to depend on the circumstances. As I said, so whether it's exclusive or non-exclusive, whether it's territorial, the term that was left to run, whether they are managing a network of sub-licensees or students, all of those sorts of things are going to cause problems and should be considered well in advance of what needs to be done, what are the consequences going to be. Then talk about refunds. So we talked about that just briefly with the last screen. But in thinking about whether you're going to offer a refund to licensees who no longer want to maintain their license, it's really important that you remember who you are and how you do business. Because if your refund policy isn't internally aligned with your values and vision and the way you relate to your licensees and the relationship you have with them, then you're not going to apply it with external consistency. Having a generous refund policy, if you are an innately generous person, is much better than saying no refunds if you cancel and then finding yourself constitutionally unable to enforce that. At the same time, you need to balance that off against the potential that you're going to feel resentful if people back out easily. So you need to make that bar relatively high and mutually fair. It's also important to think about the long-term relationship and look for win-win solutions rather than inconvenience. Because if you act solely based on your own inconvenience and the painfulness of having to process a cancellation request, then you're going to damage the relationship, and there's a whole lot of your reputation of your business tied up with that relationship. So you really don't want to piss your licensee off and send them back out into the marketplace thinking you are a completely horrible person. At the same time, you don't want to be a doormat. So it's a balancing act, and it needs to be mutually fair again. Another thing that you need to do is to make it easy to read and effortless to follow, so that you're not making them jump through 50,000 hoops at the same time as you're not sort of rolling over and letting them trample all over you. So the clearer the process is, the better, the more workflow, like if they're set out in a clear and easy workflow so they can just follow step by step by step if they have a problem, the better for everyone involved. It's also good if you can get them in for a call so that they have to talk to you about their issues they're having, so that gives you that opportunity to assess the circumstances and apply that flexibility and discretion if necessary. So termination is different from cancellation. A cancellation is where they no longer want to hold the license. A termination is where you determine that they are no longer suitable to hold the license. You need to have a process for how to identify unacceptable behaviour and an understanding of what kinds of behaviour you find unacceptable, and have that really clearly spelled out in the contract so they're not taken by surprise. If there are things that are really going to annoy you, make sure that they are specified as unacceptable behaviour. It's really important that you have a clear and fair written notification process, and that you give them an opportunity to address any issues that you identify in a reasonable time. So it's not a one strike and you're out. They have that ability to bring themselves back up to standard if it's a minor problem. There are also going to be major circumstances that justify immediate termination. Some of the most common ones tend to be bankruptcy and insolvency, because these have massive financial ramifications. But there are also, there are also going to be circumstances where behaviour is so far beyond what is acceptable that you need to be able to terminate their license immediately so that they no longer have the right to represent you, and that you can put an immediate halt to any damage that's occurring to your reputation. Once again, you need to think through, just like for cancellation, you need to think through the consequences of termination. So that might be any outstanding payments that need to be finished on either side, and also consider what IP they've been granted to, and how they're going to either return that material to you or destroy it securely, so that it no longer, like, they can't keep copies of all your files on their computers if they're no longer licensed to own that intellectual property. That's just temptation waiting to happen. So you kind of have to ask them to destroy that material, and how that occurs can be difficult when the relationship is broken down, which is one of the reasons why it's important to work out ways to preserve the relationship as much as possible, even in circumstances where a license is being cancelled or terminated. Another thing to put some thought into is your dispute resolution process. Every good dispute resolution process starts with negotiation. It starts by talking to each other. If you can't, within a reasonable time, put aside the emotions that are running high, the positional thinking, and actually discuss things with grace and compassion, then you may want to proceed to mediation and have that written into your dispute resolution process. Mediation is where a neutral third party holds the space for you to have the conversation you need to have, and guides you both to stay focused on your needs and your mutual desire to wrap this up in a way that is acceptable to both of you, rather than completely tearing the relationship to shreds and both of you losing massively. You also want to have it specified in your dispute resolution process that litigation is a last resort. You don't want to have people running to the courts and threatening to sue each other at the first sign of a problem. That's why your dispute resolution process is so important. It's not scary in the sense of inviting trouble. It's actually managing the trouble before it happens, so that when trouble does occur, you have that clear, mutually respectful, fair process that you can both follow. When thinking about dispute resolution, there are a number of different types of dispute that can arise in the context of a license agreement. So these could be disputes between the end user and the licensee, so between the student and the facilitator who's teaching the course, where it's your course. So you risk being dragged into that relationship where the dispute actually centers around that delivery. So not only might the student have an action against the licensee, but you might also, that might have flow-on consequences in terms of unacceptable behavior if a complaint is made. And that's another reason why it's really important to have your licensees required to notify you as soon as possible if there are any complaints or problems on the horizon. Another place that disputes can occur is between licensee and licensee. So particularly where it's a non-exclusive license, there's no territories and it's competitive. So that's one of the reasons why having a collaborative relationship and a collaborative management style of your licensees is really important, and really nurturing that relationship between the licensees, because it makes it easier for you to deal with personality clashes or complaints about poaching each other's suppliers or poaching each other's clients or trespassing on each other's toes. It's really up to you to manage that relationship, because conflict between your licensees has that potential to damage your brand reputation and your intellectual property and reduce the profitability of it for everyone overall. Another type of dispute that can arise is between you and the licensee, where the licensee feels that you're not fulfilling your obligations, or where you feel that the licensee is not fulfilling their obligations or meeting the standards that are required. And finally, there can be disputes with external third parties. So this could be regulatory in nature if the licensee or if you have failed to comply with some external law, and that has ramifications for the license. It could be situations where there's a dispute about the ownership of your intellectual property, whether because your intellectual property is not owned as solidly by you as you initially thought when you granted the license, or because someone else has started using using your intellectual property in a way that is not acceptable and unlicensed, and then that becomes an issue for both you and for the licensees, because you have guaranteed the licensees that they have that right, and here's some unlicensed person exercising a right outside the license. So final tips for licensing. Put in some serious thought and strategic planning. Don't just jump into it willy-nilly. It's really important that you have given it a lot of thought. As you can see from the discussion today, there is a lot involved. It's not a simple kind of relationship, and there are a lot of consequences, and those consequences aren't just for you. There's those flow-on effects that can filter out into a whole network of people, and it's your reputation that's at stake, the whole effort that you've put into building a brand. So begin by getting clarity around who you want to work with, who is suitable as a licensee, who the licensees are going to benefit, who owns the intellectual property that's going to be licensed. What do you expect to get out of it? What kinds of intellectual property are you going to license? What are they allowed to do with it? Just brainstorm, think, write down who, and then all of the different who's, write down what, all of the different what's, when's, is it going to be a term? When is the right time to jump into it? When does the license expire? When do payments due? When can someone cancel? When? Where? What kind of territory is involved? Where are people licensed to practice? Where do people go to get authorized materials? Where do people need to meet up if there is going to be that collaborative community? How are you going to manage your relationship? How are you going to keep on top of your obligations? How are you going to audit or monitor the use of your IP? How are people licensed to use it? And why? What is the intention behind all of this? Why are you doing it? Why are your licensees going to do it? Why are people going to want, why does it make sense to do it right now? All of those questions, the more you ask yourself these questions, the more you brainstorm and discuss them, the greater the clarity will be and the better your license will be. Oh, I've got someone turning up a bit late. I'm just going to finish up because I'm right at the end, and then I'll talk to them. So focusing on giving as much as you get. So it can be really tempting to see licensing as a cash cow. You've built this amazing business. Now you're going to license it and rake in the money, sit back and rake in the money. Really focus on what you are giving, what the benefit for your licensees is, and how much value you can provide to them to make the relationship that much better. And aim for that collaborative, mutually beneficial relationship with your licensees, rather than being that sort of top-down barbed wire fence style of management that we've seen traditionally. Really see yourself as providing that value and really collaborating, going into a partnership with them for your mutual benefit. So how I can help you? Oh, that is busy. I should have rethought that background. How can I help? Drafting a license agreement generally costs between $1,545, so $1,545.50, and $2,343. And I hope you can see from what we've discussed before that there is a lot of time and effort and thought on my part that goes into drafting a licensing agreement, because I help you navigate and think through all of these issues. And then there's the actually wording it in a way that is clear, easy to read, easy to follow, and doesn't trespass on any of the legal laws, so that franchise divide, and is protective of the intellectual property, and is protective of both your rights and your licensee's rights and the end user's rights, and there's a lot involved. I am happy to discuss payment plans because I don't want anyone feeling like they can't have a contract that cares when they go into licensing arrangement, they really need, you know, I'm pretty much happy with any payment plan you wish to propose, so long as it is paid in full within 12 months. So I can be quite flexible in that sense. An IP strategy session is a good way to begin. If you're just at the beginning stage of thinking about what's possible, or you want some help with that brainstorming and that thinking about that clarity, then for $330, we can spend an hour together and we can get a lot covered. Like, look at how much we've just covered in the past hour. We can cover a lot in an hour and get you really set up with clarity so that you can start really strategically planning that relationship. My website, michellewhitehead.com.au, is where you can find the IP strategy session. You'll see a little work for me, and then you go into IP intellectual property, and the intellectual property strategy session is there. If you would like to talk to me about drafting a license agreement, I suggest you use the free consultation button that's available all over the website, or the contact form, or you can email at me at michelle@michellewhitehead.com.au, and we can take it from there. These prices are, of course, current at February 2020 and may go up around the end of the financial year, so around June, July. But we will see. They may as well stay the same. Just because this video is going up on YouTube, I just want to add that in as a bit of due diligence in case someone watches it years to come and then says, I need to one of those previous prices, which is why it's important to also factor into your licensing, particularly if it's a long-term license and it's renewed every 3 to 5 years. You might want to factor in price rises due to consumer indexing, or the growth in the brand over time and those sorts of things. That's another thing to think about. Okay, I hope you've enjoyed this exploration of licensing. We didn't run as much over time as I was scared we might, but I think we've covered a massive amount today, and I hope you found it useful. And I look forward to seeing you on the next episode of the Serenity series. Bye for now.